We are here today to talk about that scintillating cocktail conversation of contracts and U.S. Coast Guard. And I have with me our Admiralty attorneys that have helped us so much with these contracts, from Clinton and Musica in Boston, Massachusetts. We have John Bromley and Bob Collins. We have set them up with a roundtable as part of our roundtable after the seminar, and so they are here, well, at the end of this seminar panel discussion to answer questions, but also afterwards to answer any questions at their roundtable that you might have about contracts or any other particular aspect of Admiralty legal issues. So we have finally almost finished our revisions of the 3 AYCA contracts, 2 demise contracts, which are the recreational bareboat contract and the vessel services contract, and then the uninspected passenger vessel contract. What we have now are almost completed drafts. If anybody doesn't have a copy of the contracts that would like to have copies, please raise your hand and Carol Kent will give you the copies that we have. Now these are drafts. They are not ready to be used and they should not be circulated. When we do have them finalized, they will not come out in hard copy paper form or as attachments. They will only be on a locked e-contract platform, just like the MEBA contract, just like the CEBA contract today, so that there can, unfortunately, there have been bastardized versions that have circulated, and so we found, just as MEBA and CEBA found, that the contracts have to be on a locked e-contract platform. We haven't finalized exactly what that will be within the AYCA. We have various options that we're looking at, but everybody should be aware that if a paper copy comes or they get sent as an attachment and they do not appear as though they're from, and well, our e-contract platform isn't live yet, that it's not an actual good version of the AYCA contract. So let's go a little bit further into what our actual revisions have been, what the purpose of all of this was. AYCA is a sister organization with MEBA, and so what we've done on these 3 contracts is we have brought our contracts into compliance with MEBA business terms as much as possible. MEBA legal venue is British Admiralty law. Our legal venue, of course, is American Admiralty law. American Admiralty law and British Admiralty law do have some differences. Small, but there are differences. So when I say we brought these into compliance with MEBA business terms, it's as much as possible in accordance with American Admiralty law. Also, all 3 of our contracts have exactly the same clause numbering as the MEBA contract. So if in the MEBA contract, clause 16 is insurance, it will be insurance in all, clause 16 will be insurance in all 3 of our contracts as well. So now everybody can feel comfortable that every clause number, that the clauses are the same for the MEBA and all 3 of the AYCA contracts. Now, we say 3 AYCA contracts because it's extremely important to recognize that the demise contract package is really 2 contracts. I hear people say, you know, the 2-part demise contract, or the demise contract is, and that's actually not technically correct. It's the demise contracts are, and they're not 2-part, they're 2 separate contracts. That's
very important.
Yes.
That's very important.
Yes. because this is what the whole basis of the relationship, this is what the U.S. Coast Guard wants to see. They want to know that the yacht is bareboat chartered with no relationship whatsoever to having crew on board. Crew are brought on board by hiring on a separate agreement a contractor to supply the crew, but completely separate agreement. This is really the first time that these agreements have been completely separated so that there are two distinct contracts, each of which can stand alone. I keep hearing about simplifying the demise contract or the simplified version of the demise contracts. Well, I'm afraid these contracts are longer. So they are not simplified because you have to have in each contract to stand alone. If there is a term that deals with, say, breakdown of the vessel for the 80% payment on the recreation contract, you need to have that same clause in the crew services agreement to deal with the other 20% of the charter fee that the client has paid. So every clause that's in the recreational bareboat agreement is reflected as well in the crew services agreement, so that every aspect of the crew hire, so the base charter fee is for the yacht and the crew hire. Every aspect of the yacht fee and the crew hire fee are dealt with in each contract. The bareboat contract, should you take it and just use the bareboat contract, can stand completely alone. You can also use the crew services agreement should you choose to just hire crew without a yacht, but it can stand completely alone. That is extremely important.
And it's important to point out it's not a matter of them being repetitive, they're mutually exclusive. So that can't be stressed enough. They are separate contracts, not something that's repetitive with the other, because they're not co-joined.
It's not a two-part contract. It's two separate contracts. One dealing with 80% of the yacht hire fee, and the other dealing with the 20% of the crew hire fee. Two separate fees that we do quote as one, but they are actually, it's the charter fee is the yacht hire and crew hire fee, divided between two separate stand-alone contracts. The other very exciting part of our Demise 2 contracts is that we have developed, the AYCA has developed a good relationship with the U.S. Coast Guard. And we are communicating with Lieutenant Commander Mason Baxter, who is in charge of inspections from Washington, D.C. to Maine. We sent our two demise contracts to Mason Baxter, and he sent them to the legal department in Washington. And the response back is that our two demise contracts are an excellent reflection of the Passenger Vessel Safety Act. This is also extremely important. As we all know, the Coast Guard is never going to rubber stamp the demise contracts or a demise charter arrangement. They consider it a shade of gray. Every captain of every port has the right to interpret what he views to be a legal demise charter. The Passenger Vessel Safety Act is one of the main pieces of legislation that actually mentions the demise contractual relationship between the charterer, the yacht, and the crew hire agreement. There's 7 points laid out in a Coast Guard NAVIC that are supposed to be, the majority of which are supposed to be in place for a proper demise contractual arrangement. This is what the U.S. Coast Guard has said on review of our two demise agreements, is that it's a very good reflection, excellent reflection actually, they said, of the 7 points that should be in place for a proper demise agreement, relationship agreement. That is what the U.S. Coast Guard has laid out in this NAVIC for the Passenger Vessel Safety Act. So this is a very good reflection of the Passenger Vessel Safety Act. So we were very happy to have that back. The uninspected passenger agreement also has been brought into the same clause numbering, the same business terms as MEBA, as much as American Admiralty law allows. The U.S. Coast Guard has asked us to add in one clause on sexual harassment, which we are adding to all 3 contracts. For some reason, it didn't get into this bareboat agreement draft. But again, these are drafts. They're not ready to be used. So, and also asked us to take out the restriction on not bringing pets on board the bareboat agreement. So those were their only 2 comments, and we made those changes to comply with their requests. It should also be known that Yachtfolio accepts the MEBA and the AYCA contracts. Our E&O insurance providers accept the MEBA and the AYCA contracts. Hull insurance providers that are providing hull insurance for yachts and charter accept the MEBA and the AYCA contracts. And also, charters legal liability insurance companies accept the MEBA and the AYCA contracts. You should be very careful using any other contract to be, realize that it may or may not be accepted by Yachtfolio or by your E&O insurance provider or charter's legal liability insurance provider or the hull insurance provider for the yacht that's in charter. Now, when these contracts come out, this is what's happening with our current AYCA contracts. Before these contracts come out on an e-platform, we will also have sent them as revisions to charter legal liability insurance companies, just to show them what the updates are and make sure that they're also reviewed and accepted. So, that's my speech. Any questions? And any questions for John and Bob?
Something I want to point out, and I'll tell you like you don't know, but most of you probably do know this, but Bob had a good point. It's important to point out that bareboat and demise, sorry, I'm getting feedback. Bareboat and demise are the same thing. Time and voyage are 2 totally separate things. So when you hear the terms bareboat or demise, they're used interchangeably. I usually stick with bareboat because I like it better, but demise works as well. It was very important that they ran these by the Coast Guard, and I'm glad that they did. The PETS provision, for instance, is something that helps illustrate one of the most important features of a bareboat agreement, and that goes to control. Who's in actual control of the agreement? Because a bareboat, and that's why I like the term bareboat better than demise, a bareboat is you get the bare boat. It doesn't have anything on it. You're going to provision it, you're going to crew it, you're going to staff it, you're going to do whatever you want to do with it. The vessel's yours, but it's a bare boat. And that's where the vessel service agreement comes in as a separate contract. And why I said before, it's not repetitive, it's mutually exclusive. So the vessel service agreement comes in because the charterer is actually hiring the captain and the crew. Now, it's best, so that it's not seen as a workaround, it's best if there is a selection that can be made. I know that's not always the case, but the yacht owner, for instance, is going to have a captain and crew that's familiar with that particular vessel and that they have vetted. And I think it's important that your clientele picks someone that's been vetted by the owner of that yacht so that they get the best experience they can get. Where possible, it's nice to have a choice so that if the Coast Guard were to drill down deep enough, they don't see that, well, it's a vessel services agreement, I get that, but there was no real choice over who you get to use. But the counter to that is you do have the right to hire and fire. And as the charterer has that power under the vessel services agreement to hire and fire a captain or crew, then that helps preserve this as a bareboat agreement. I hope that makes sense. Bob, did you want to add anything, or
No, not really. I
any
don't have
feedback?
anything else to- No.
I'll go back on
Here, you
that,
can have
though. One aspect that we have been talking to the U.S. Coast Guard about, that was to our Mason Baxter, is the fact that the captain, that a good broker makes a recommendation and should be making a good recommendation. And so the one thing that we're doing is recommending that the charterer hire the captain that's approved by the Hull Insurance Company. So you can bring your own captain on board, but that captain also has to be approved by the Hull Insurance provider. And that means that they're going to have to go through training on board. The charterer is going to have to charter the vessel for the additional time for the training, and then that person may or may not ever be approved by the Hull Insurance provider. I mean, you can't just bring somebody who's, doesn't have the right captain's license on board. No matter how much training he has to run that vessel, he may never be approved to run it. So it's best to, the Coast Guard was confused as to why it always seemed to be that the captain that was already on board the vessel was the captain who was being hired by the charterer. And they felt that we were not properly selling the bareboat crew employment to separate contracts, and that we perhaps were having a commercial vessel masquerade as a two separate contract bareboat and vessel services hiring. But we've explained it probably is going to be the same captain that the owner uses as well, because the captain is approved by the Hull Insurance provider. But what we're doing is recommending to our clients that the best captain for safe navigation of the vessel is the captain who's already on board, trained, and approved by the Hull Insurance provider. Not approved by the owner, not supplied by the owner, approved by the Hull Insurance provider for safe navigation of the vessel. Also, the Hull Insurance includes medical for the crew that's named on the Hull Insurance policy, which is going to be the crew that's been approved by the Hull Insurance provider to be on board. There are two types of Jones Act disability insurance that an employer of maritime crew or maritime employees should also be offering, which means your charterer should be providing through the contractor to the crew. And that is also in the Hull Insurance policy for any crew already approved to be on board and named in the Hull Insurance policy. So this, as a broker, to recommend that they hire the crew that are approved by the Hull Insurance provider for safe navigation of the vessel, means you're also providing the charterer the protection of the crew having medical insurance and the crew having the two types of Jones Act disability insurance that the charterer is liable for to be providing to the crew as the crew employer.
Good points. I don't have anything to add to that. You have a question?
Hi, good morning, everyone. I would like to know if your contracts, once they're finished and online, will it be required to be a member of AYCA with access to it, or will it be similar to FIBA and SEBA, whereas it's independently approved based on certain criteria?
It will be independently approved based on certain criteria. Yes, it'll be available to the industry that are qualified to use these contracts on an individual basis.
Great. Any other questions? We also have the round table if you want something. Oh, I'm sorry. Didn't see you. Say again. I'm sorry. It depends on what the challenge is. I hate to, I'm not dodging the question. I just honestly, it depends on what the challenge is because each agreement is its own beast. And it really just depends on what they're trying to challenge. For instance, there was a clause in one of the earlier drafts that talked about pets and how pets can't be on unless the owner approved. That's something that the Coast Guard, I believe, had recommended be taken out because that goes against showing that there's control over it, because the owner of the vessel shouldn't have decisive power over who and what is on board the vessel during a bareboat agreement. So that's just one example. Do you have a specific example in mind? I can't hear you. I'm sorry. Yeah, if I heard you correctly, I'm sorry, my hearing is horrible. So if I heard you correctly, there was a boarding in Maine or a couple boardings in Maine, and they challenged the bareboat agreement. But what was the challenge based on?
So what a captain should say if he's challenged in the demise contract.
Yeah.
Definitely, he should say he was hired by the charterer. I think it's, the question is about advice on what the charterers, the captain should do if boarded and challenged on the validity of the demise contract. And obviously, of course, the captain should be saying that he's hired by the charterer and that he works only for the charterer during the time period of the contract. And
it's all true. I mean, it's a matter of really kind of reaching out. I mean, I'd have to see the agreement that they said they didn't recognize. You know, if it's something that's been vetted by the Coast Guard, even though I understand they won't stamp it, I think you got a better chance of overcoming any challenges or at least addressing them. Do you have anything to add?
It seems like a very odd thing for the Coast Guard to say, frankly. There are many types of charter agreements. Whether or not they recognize it is relatively irrelevant. The important thing is the terms that are in the charter party. And I would recommend if the captain is challenged by that, by the Coast Guard, to either call Missy or call an admiralty attorney. You don't want to take that. You don't want the captain taking on that question.
Yes.
Just to validate what you said, I had the same issue on a large vessel over 100 feet with this contract.
And
To validate, so I know it is probably a lack of knowledge on their
Right.
part, but boarded, challenged. It went fine, but it was obviously stressful and time consuming for everyone. So just wanted to validate her and see.
right, every captain of the port, and there are various marine safety districts up and down the East Coast and the West Coast and Alaska and Virgin Islands. Every captain of the port has the right to interpret the gray area of the demise contract. It's going to be an issue forever because the U.S. Coast Guard does not acknowledge that the demise contract is legal. They will not say, yes, this is a legal contract, and if this contract is in use, that's terrific. It's a shade of gray. And it also depends on how this contract was sold to the charterer. It may say that it's a bareboat contract. It may say there's a separate crew employment agreement. But does the charterer realize that he, in fact, chartered the boat on a bareboat basis, and he, in fact, is the one that hired the contractor to hire the crew? And that is really the big issue with the Coast Guard. The Coast Guard wants the public, that unsuspecting public, to be totally aware that they have an extra liability exposure. Everything has liability, but extra liability exposure when they are chartering a vessel on the two demise contracts than if they chartered an uninspected passenger vessel contract on an uninspected passenger vessel contract. So they feel that the public may be, calling a charter broker, and the charter broker is saying, oh, yes, take this lovely yacht, and here's a couple of contracts, sign them. And they're not explaining what the liability exposure, additional liability exposure is, so the charterer can say yes or no. And also, they're not saying, but here's another yacht that is on an uninspected passenger vessel contract where the owner supplies the crew and it has less of a liability exposure. Which one do you want? They want to make sure that the charterer is fully cognizant of his additional liability. They also want every charterer on the two demise contracts to be offered charterer's legal liability insurance to respond to this additional liability exposure. At least know that the insurance is there and they had the option to buy it to protect themselves. It's all about protecting the public, the unsuspecting public is what the Coast Guard says to me, from not being taken advantage of, not being placed in an increased liability exposure, at an increased liability exposure without being educated and given the opportunity to be insured against it. And that's what really makes them crazy about the demise contract. That and the fact that it seems to always be the owner's captain on board when they board. So remember, it's the captain that was approved by the hull insurance provider for the safe navigation of the vessel.
Yes.
Has there been any legal precedents set down by any state or federal courts in relation to contracts where a potential owner got into trouble or a captain got into trouble and it actually ended up in the courts?
I don't know of any. I haven't researched it, but I don't know of any where the Coast Guard's been challenged on something they deem not to be a valid contract. It'd be an expensive thing to pursue. Oh, Missy does though. Hold on one second.
Sorry. I do know that it has stood up in court that it is legal to hire the same captain that the owner might be using for the safe navigation of the vessel as approved by the hull insurance provider. That has stood up in court. Why, no, I don't. I just know. I think it was in Florida. I just know because I was involved in writing the Passenger Vessel Safety Act, that when we went through that part of the Passenger Vessel Safety Act, that the Coast Guard told me that that had stood up in court and that they could not include in the Passenger Vessel Safety Act anything negative about hiring the same captain that the owner happens to be using as well. And Scott, the vessel can't, once the vessel, I've confirmed with John and Bob here that once the vessel is exported, American late haul vessel exported, foreign and goes foreign flag and loses the right to coastwise trade, that law was removed. It can come back and get coastwise trade again.
She's right, it can. Yes.
Should the captains have an LLC in their name? I've always heard that on contracts, they should have to use their own name. They should have a company set up to protect themselves.
Meaning they should not, because it's a contractor, meaning that the captain should not just be the contractor.
Right.
Because the captain shouldn't take the personal liability.
Right. Yeah, I mean, that's the only thing is, if you have enough insurance, you don't worry about it. But if you don't, then being an LLC is always the preferred method. Because you protect yourself from personal liability of your house and... Right.
It's just a question of personal liability protection. It's just a question of personal liability protection. I certainly wouldn't want my name as the contractor on hiring the crew and all the aspects of if a crew gets injured, if a crew, I mean, plus. Right, you want it to be an LLC or corporation because you want to be able to have that on the hull insurance as an additional insured so that the contractor can actually have access to the medical insurance and the two types of Jones Act disability insurance that are in the hull insurance policy. I mean, it's kind of, you know, the owner has access to it when the owner uses the crew that are approved by the hull insurance provider on a demise, on yachts that operate on the two demise contracts, but the contractor does not have access to offer that same insurance that's just sitting there in the hull insurance policy, so definitely should be access to protect the crew and protect the charterer from the liability of the responsibility of offering medical insurance and the two types of Jones Act insurance, but the contractor doesn't have the right to access that insurance in the hull insurance policy unless they are a named additional insured. And if it's in a personal name, if it's one person's name, then he has access to the medical insurance and the hull, but how can he give it to, if it's the captain and it's just in his name, how can he give that same insurance to the chef per se? Unless it's a corporation where he's hiring the crew. Right? I'll let you answer that because that's a
Can you repeat that?
I think we got the answer. It was about the net payments at the end that they have to go to the owner's company, the vessel, and also to the LLC or the vessel services.
So you have two different entities on
Right.
each yeah, and so should you split the charter payment at the end when you're sending it out to them and pay each entity correctly in accordance with the contract?
Well, yeah, I mean, you should pay them in accordance with the contract, and that way it shows as separate. And for the broker to be the one that splits that out, I think that keeps it fair. I don't know if that answers your question, I'm sorry.
I agree, it's what I do generally, but I have some other questions.
Okay, yeah, no, I don't see a problem with that at the outset, but, okay, we might have gone over, because I see Neil there.
Yeah, and you guys will have a roundtable as well, right?
Yeah.
So please follow-up questions, during the breakout sessions at the end, you guys will be available?
Yes.
Thank you.
Yes, okay, thank you, everybody.
Thank you.